At this time, I will call the next case on the docket, 117973, Brian Russell et al. Versus Trainer Investments LLC and 8th and New Hampshire LLC. Mr. Russell.
May it please the court, I'm Brian Russell. I am the appellant, and I'm here seeking review and reversal of the lower court's rulings on both contract and property law grounds, or failing that, remand on summary judgment procedural grounds. And if I may, I'd like to reserve 6 minutes of my time for rebuttal.
6 minutes is reserved.
Thank you. In 2010, probably like many of you, I had gotten out of school, I had begun my career, and I was ready to make the biggest purchase of my life, my very first home. And I was interested in a condo in Lawrence where I had gone to school. But the condo building was adjacent to a commercial building, a bookstore, and I knew at the time the way that the world was going, bookstores were going out of style, and I was concerned about what could end up next door to me if the bookstore did go out of business, which it since has. And so I looked very carefully to see if there were any restrictions on what could be in that building, and I found that there actually was a set of restrictive covenants contained in a document called an Operating and Easement Agreement, OEA, that were very specific in prohibiting any larger footprint than the one that was already there. So somebody couldn't come in and tear that building down and build a wider building, and it could never be a grocery store. But being an attorney, I was further concerned about how those covenants that I liked might ever get changed. So I went through the document carefully, and I found that it had a section expressly titled amendments that said the only way that those covenants could ever be amended was with a writing signed by each and every owner. And at that point, I felt protected. I went ahead and I purchased the condo. Fast forward 6 years, I'm told that Trainer Investments LLC had purchased the building, which was the adjacent building, which was then vacant because the bookstore had gone out of business, and that he was going to not only knock it down and build a building twice as wide, expand the footprint to double what the original footprint was, which was prohibited when I moved in. He was also going to put a grocery store into it, which was also prohibited when I moved in. And that he was going to do that whether the people in my building liked it or not, with or without my signature. And I said, no, you're not. And I went to the district court and then Court of Appeals, and I've been told now by 2 courts that I missed a loophole, that some prior language in the OEA about the powers of somebody called a representative owner in my condo building, this language was implicit, not explicit, and general, not specific, but nevertheless it trumped the explicit and specific language of the amendments clause, that the person responsible for seeing that the OEA was performed on behalf of us condo residents could also get with the owner of the adjacent building and rewrite the terms of our communal living arrangement anytime they wanted, even if it was detrimental to the rest of us, even if we objected. And I've been told that that was obvious and I should have seen it. And so I'm the sucker, for lack of a better word.
About this a little bit. I think I'm correct, having looked at all of this, that in the original OEA, the phrase representative owner does not appear. It's responsible owner, right?
Responsible owner,
So
yes.
the term, whatever the term may mean, the term representative owner doesn't show up until the amendment.
I believe that's correct.
And it also, and actually that term shows up in the same paragraph where it also talks about responsible owner. So we have to figure out whether there's a difference there. Let's assume that these documents are badly done and are vague. Where does that get you? Because if we said it was vague, the lower courts were wrong on that part. And so we have to go back and get evidence about what was intended when the amendment was put together. You're not a part of that dialogue anyway, because all that happened before you show up. It's really just the parties, you know, the books, the Lawrence store number and Winter and 8th and New Hampshire. But those are the people that are going to say this is what they meant to do. Presumably they're going to say they meant to do the outcome that you lose. So where do we get with remand? If we were to find it's vague, is there something that you can work with that would indicate you prevail?
A couple of things.
If this thing's vague.
A couple of things. One is the first amendment to the OEA, in terms of this case, the only thing that it did was it designated 8th and New Hampshire LLC as the responsible or representative owner. It didn't.
I don't think you can be that flip with the adjectives. That's what I'm focused on here.
Okay.
I'm not sure that responsible owner isn't something different than a representative owner.
Okay.
And if it is, how do I figure that out? Because it's not defined in the amendment. It just shows up as a term.
Do you have a question about what the difference would be?
Yeah.
Okay.
Seems like they have to be different.
So
Why are we? And I think I think everybody got a little sloppy in going responsible or representative owner. I see the terms not being a slash or anything. There's a responsible owner, there's a representative owner, and I need to figure out whether they're different. And I don't see anything in the amendment, which is the first time the representative term shows up, that tells me what that term means.
Okay. My position would be that it's a distinction without a difference, because if you are responsible for the performance of the provisions of the OEA, or if you are to represent the rest of your fellow condo owners in the performance of the provisions of the OEA, in neither case do you get to rewrite the OEA. Performance means the carrying out of a contract. It doesn't mean the formation of one or the reformation of one. And both lower courts have opined that the person responsible for the performance of the OEA, for seeing that the OEA was performed, gets to then perform that amendments provision that says for amendments you need the signature of each and every owner. And by perform, it doesn't just mean that that person gets to run around and ask all of us fellow owners, hey, we've got a proposed amendment, would you be willing to sign it? They actually get to go ahead and make the decision. They don't even have to ask us. Make the decision and sign for all of us.
I don't mean to overemphasize this point, but I understand the argument when the term is responsible owner in the first OEA. Because there it says, responsible owner for the performance of the provisions. That I got. But now I've got this new animal
Yes.
in the amendment that says representative owner.
Okay.
And so that's where the sloppiness comes in. Do we somehow have to imply that that the representative owner has some other authority to modify the whole agreement
Okay, I think I see
Put in a
where,
grocery store.
I think I can help.
Okay,
At the very beginning of the First Amendment, it begins the part where they designate themselves to be this responsible representative owner. It begins with pursuant to Article 2, Section 2.4 of the OEA. So I think that right there indicates the intent here is to designate ourselves to be the person talked about in Article 2, Section 2.4 of the OEA. So that's why I'm saying that First Amendment, in that First Amendment, they didn't give themselves any new powers. They just designated themselves to be the person who is talked about in the OEA, Article 2, Section 2.4. So we have to go there to see what their powers are. And it says that they are the ones who are supposed to see that the OEA, the performance of the OEA, the OEA is performed on behalf of the rest of us condo owners. And my point all along has been performance doesn't mean amendment. If you have a delegation to perform a contract for somebody, even if it has in it, like many contracts do, some kind of a statement about how it can be amended or how it can be changed, you don't get to then use your performance delegation to then get with the other party and rewrite it and say, well, I was performing an amendment. I was performing changes. I think we have to be really careful here about what performance means. And I think one of the things that the Court of Appeals said that I think was absolutely correct was the primary rule for interpreting written contracts is to ascertain the party's intent. I think that's absolutely right. And when the OEA was originally drafted, it was drafted by one person because it was drafted by the person who at that time owned the entirety of the block. It's the two tracts that ended up being the condo building and the other building. And so we have to look to his intent. And when we do that, it's clear to me that whatever he meant up here in Article 2, Section 2.4 for the representative or responsible owner to be able to do did not include amendment. How do we know? Because many, many sections later, down in Article 6, Section 6.11, he puts in the amendments clause where he says the one and only way to amend is with the signatures of each and every owner. I would submit to you, we're all lawyers here, that none of us would have drafted an instrument that way if what we had meant, none of us would have drafted Article 6, Section 6.11 about amendments that way if we had meant 4 sections earlier up in Article 2, Section 2.4 that the representative or responsible owner got to amend. We would have said something like, the one and only way to amend this is with the owner of the bookstore building and the representative owner of the condos signing, or something like that. And I think it's also important here to remember that at the time that First Amendment was made, this First Amendment that you're talking about, 8th and New Hampshire LLC was the sole owner of the building in which I live. There were no other condo owners yet. At that time, they could have rewritten the OEA any way they wanted that the bookstore owner would have agreed to. They could have stricken that amendments clause, and they could have replaced it with, the only way to amend this is with 8th and New Hampshire LLC and the bookstore owner agreeing. But they didn't.
well,
And I think we have,
it's true that isn't it, that the amendment was entered into in the contemplation of building the condominiums?
yes,
I mean, there wasn't a building yet.
correct.
Okay.
They could have changed it, but they didn't. And so I would ask you to think about why not? Did it really not occur to them that when they went to sell condos, buyers like me would look at that amendments language and think that those covenants protected us, and because our signatures would be required to make any changes? I think it probably did occur to them. And I think that they wanted to sell condos, and they knew that if buyers like me had reason to believe that those covenants were worthless, because at any moment, 8th and New Hampshire could come in and bait and switch us after we paid for our condos and change them or waive them. They couldn't have gotten nearly the prices they got for the condos. And so I think they did know that people like me would be lulled into feeling protected by the covenants, seeing that amendments clause that required our signatures. And so I think it is unconscionable now for them to say, well, we want to have our cake back when we're trying to sell condos and let people feel protected, and then we want to eat it too now, years later, when we've sold all the condos and now we have a chance to make another deal for ourselves. I think that is ethically, morally, and in this context, most importantly, legally,
What
not
happens to the,
correct.
if we apply the original covenants as you're arguing, and there's not unanimous, and say that the original covenants apply, and there's not unanimous agreement, does that lot just stay vacant? What happens to that lot?
No, there are lots of things they can do with that building. They just can't
But-
put a grocery store in, and they can't make the footprint bigger.
Other than that, they can do what they want.
Oh, sure. They could carve it up into smaller commercial spaces if they couldn't. So it's 20,000 square feet. If they couldn't get somebody who wants 20,000, they could carve it up. They could go. They could go up. They can go up 90 feet. They could do apartments. They could do a lot of things with it. And that's another point that I'd like to just make. If you're a developer and you want to sell homes to people with the benefits of restrictive covenants, but then you want to be able to come in after the sale and change the covenants, then as the Cokinge court said, you have to make that crystal clear to the buyers so they can factor that in, that those covenants really should not be relied upon at all. But the flip side of that is, and that's 8th and New Hampshire LLC's position, if the flip side of that is if you're in Trainer's position and you come in and you buy a building that's burdened by restrictive covenants in the state of Kansas, you need to expect to have to follow them, not expect to be able to find some loophole in them and then just do what you want to do and then have your neighbors and the courts let you get away with it.
Are there other questions? Thank you, counsel.
May it please the court, Todd Thompson for Trainer Investments, the owner of what we're calling the Borders parcel, the north half of the block. First thing I want to point out is that the plaintiff thinks he bought a veto of any further changes, but he was on notice that that was not the situation. Indeed, there had been an amendment to the covenants which changed the available options for development on the south half of the block. In that amendment, they changed the size of the building.
That's the 2004 amendment? The May
Yes.
2004 amendment? Okay.
They changed the size of the building. They changed the location of the building. They changed the height of the building, went from 2 stories to 5 stories. The plaintiff lives in one of those 3 additional stories. So he, as a lawyer, had to look at the First Amendment and say, oh gosh, they've changed the covenants to increase the size of the building from 2 to 5, to change the uses and add a drive-up window. They added a drive-up window to that facility. They changed the shape of the footprint. They changed the square footage of the property from 50-some thousand to over 100 or to 125,000 square feet. And indeed, he lives in some of those additional square feet. They changed the parking layout.
Look, counsel, I want to get to my concern here. We can look at the document and see what the different things that are changed. But you would agree with me that in the first OEO, the original OEA, the term representative owner isn't in there, right?
Yes.
So when this amendment says pursuant to that OEA, Eighth and New Hampshire is now the representative owner, is that trying to communicate a new animal with new authority, or is it simply kind of sloppiness that it should have said responsible owner and it said representative owner instead? I think that's really pretty central to this discussion.
Well, to the point, I think the language is clear that the representative owner is designated to represent the other people in making decisions.
I don't think that's true. I think you've got to tell me that term either is a new animal with new authority, or all we were trying to do was reference back to the original OEA and just make Eighth and New Hampshire the responsible, what was termed the responsible owner in the OEA.
The word representative is in lowercase when it's first mentioned in 2.4, I think it is.
In the amendment.
In the amendment, correct. So
it's
it
not,
is.
so you're telling me it's not meant to designate some additional authority that didn't already exist in the OEA for the responsible owner. This is just imprecise drafting, if you will.
Perhaps, although I think it makes it more clear that the responsible owner is representing
How does
and making
how does
the
it do that
decision.
without explaining that we've got different authority than what's meant to be communicated? You're telling me that responsible communicates one level of authority and representative communicates a different level of authority.
I'm not telling you that.
Okay.
I'm telling you that the First Amendment, in my opinion, and in the district court's opinion, and in the Court of Appeals' opinion, says Eighth and New Hampshire is going to vote or make the decision for the south half of the block. And plaintiff was
And
incorrect.
did it have that authority under the original OEA if it had been the responsible owner under the terms of the OEA?
Did you say he did not have the authority?
I'm just trying to figure out whether the term representative, if I can substitute in the amendment the term responsible owner as it exists in the original OEA. That's all I want to know. Because it's either that or you intend to create a different level of authority in some other entity called a representative owner. You've got to be in one of two places on this thing. Can we just put responsible owner where it says representative owner and reference back to the OEA?
I believe you have to look at the amendment as having done two things. Clarifying that Eighth and New Hampshire has the authority to make the decision, and perhaps more importantly, the First Amendment was to change all of those items I mentioned a minute ago, to increase the size, to
I
change the
understand. I'm
footprint.
really only focused on this 2.4. It says pursuant to 2.4. And you don't tell me in the amendment, you don't tell the reader in the amendment that you're giving this representative owner greater authority or wider authority. You say you're trying to clarify, but there's no reference to clarifying any authority. You're simply using a different term, and that's got to either be substantive or just imprecise reference.
But does that matter? I don't think that matters, whether it's substantive
So if it
or
doesn't matter, can I
imprecise.
just substitute responsible owner where the amendment says representative owner?
What matters is that the language of both in the original document and the amendment, considered together, which is what you have to do in construing the contract, clearly gives Eighth and New Hampshire the authority to make the decision on amending the covenant.
So where in the amendment does it say that there would be greater authority to the representative owner than what the responsible owner had under the original OEA.
And I don't think it says there will be greater authority,
Okay.
but I don't think it needs to say there will be greater authority. What it says is there is this authority.
Because it's your position that that authority already existed in the original OEA. That's all I'm trying to get to.
Is it, I may make this worse or I may be able to help. Is it your argument that the language in the original OEA, section 2.4, that talks about shall designate one of their number to act on behalf of all such owners, that's what they're talking about, the representative owner?
Yes.
That's what's being referenced in the amendment, is the authority to act on behalf of all such owners.
To act on behalf of
That's
that
your
whole
argument,
half
right?
of the block.
Is that the answer to Justice Biles's question?
Well, I don't think you take that clause in isolation. You also look at
I'm just
the
trying to
amendment.
get at what was meant in the amendment by the term representative owner. Isn't that referencing back to the language in the original that talks about designating one of their number to act on behalf of the other owners? That seems to me to be a dictionary definition of representative.
I would agree with you.
Okay.
The trouble sometimes with a petition for review is you don't know exactly what the court's focus is going to be. I want to go back and talk about the procedural issues here. Plaintiff in the amended petition in paragraph 14 says, I want this considered on an expedited basis. Plaintiff never asked for discovery. Plaintiff never asked or complained and said there are factual issues that need to be ferreted out. And yet that's what plaintiff is now here before this court doing. And we don't believe that's a proper request for the plaintiff when the plaintiff essentially invited what the plaintiff is now saying was error. Because we got summary judgment, we got an expedited ruling, plaintiff requested that in the amended petition himself, so he can't come here today and ask you to find that error. It hasn't really...
Both of the parties told the district court the contracts, the documents were unambiguous, right?
Correct.
And neither party suggested there should be any extrinsic evidence presented.
Correct. Are there any other questions in my last 9 seconds?
Thank you.
Thank you. I will yield to Mr. Emmer.
May it please the court, my name is Mark Emmert. I'm here on behalf of 8th and New Hampshire LLC. 8th and New Hampshire is, of course, the owner of what is known in the OEA as the development parcel.
And the long litany that your co-counsel described that was that were amendments made in that the amending document, those were all on your parcel, right? Not the board's parcel.
Justice Breyer, the amendments would apply to the entirety of the land. They were intended, of course, at that time when the amendment was made in 2004, the Borders parcel was already there. The operation of the bookstore on the north
Right.
half was already there.
And
It
so
was
I'm
in-
saying those things that he said they changed at the time of the amendment were changes that would apply to the condo building and whatever retails there with it, not to the Borders building that already existed. Is that right?
Well, the purpose of the amendment was to allow for the kind of change that the development parcel, the 8th and New
That's what I
Hampshire
thought.
parcel intended. Of course, it would apply evenly across
Okay.
both of the
To the
parcels.
extent they were covenants that ran with both parts of the,
Exactly,
Block,
Justice Breyer.
okay.
To the extent that they were as part of it, then they applied equally to both.
okay, thanks.
When they purchased, or when I want to at least briefly touch on what Justice Biles had previously mentioned. I've had the benefit of listening to the questions while Mr. Russell was before the court, and then again, Mr. Thompson. I think that what you were getting at, Justice Biles, if there is a vagueness, what are we always told? that the four corners of the document, the entirety of the document, control what was the intent of those who drafted it. And I think that Mr. Russell had indicated that it was just the Winters at the time in 1997. That wasn't true. The Borders parcel had been contemplated. In fact, it's actually mentioned expressly in the OEA. But if you take the OEA as a whole, you'll see that the entirety of it is referred to as a shopping center. That means in the recitals, which are part of the OEA, restaurant, retail, and office complex. You'll see specifically that it was intended almost exclusively for commercial purposes. Each party or each owner of the parcels made representations to the other about restrictions on construction and making sure that they didn't interfere with the going operations of the other. And those going operations were business purposes. Specifically in Section 3, you'll understand that and note that they were intended to provide guidelines for how the businesses operated. And so when we get specifically to your question, Justice Biles, looking at the entirety of that, if we want to just look at subsection 2.4, your question about what does responsible mean? Well, responsible in this context was noted one time, and that is at the very end of that section 2.4, that responsible is referred to as the owner to act on behalf of all of the other owners. Section 2.4 necessarily contemplates that the parcel may be subdivided at some point in time. Now, in 1997, they may have thought it would be subdivided into a restaurant here and a professional office next to it, and that those were separated by owners. But in any event, when it says that if the parcels are to be subdivided, then that owner shall designate one to act on behalf of all of the other owners, and owners with a little o, right? If they fail to do it, and there's a mechanism for recording that, but if they fail to designate one owner to act on behalf, then the owner of the largest subparcel shall be the responsible owner. Responsible refers to acting on behalf of all the other owners. And as Justice Stegall pointed out, when we get to representative owner, that's still acting on behalf of the other owners. I don't know, I wasn't part of that process about whether or not there's supposed to be a difference between representative or responsible. I think read in context of the entirety of what they were expecting is that there would be one owner. And one owner would have the ability to perform all of the other obligations, to act on behalf of all of the other owners in any other matter as it's contained in the OEA, excuse me, and the subsequent amendment.
So can I substitute the word responsible for the word representative in the amendment and be just fine in terms of how you think these documents ought to be interpreted?
My position is I don't think that you can't substitute it. It's what's written is written. But I think that when you
For
look...
purposes of understanding, I mean, there's a precision that's required in commercial transactions and commercial drafting. And so when we're trying to figure out, especially as counsel points out, at this time that you're doing this amendment, you can do anything you want because you've just got a limited number of entities that have to consent. You can say you could have created an entity called representative owner and defined its authority and designated 8th and New Hampshire as that thing, and you're off to the races. But instead, we have a document that says, pursuant to the old document, we're designating ourselves the representative owner, only the old document doesn't have that term in it. And I'm trying to figure out, looking at the four corners of the document, whether that's a substantive change or if it's just the imprecise use of an adjective, where it could have just as easily said responsible. That's what I'm trying to get at here.
I think I understand the question a little bit better now, and I think maybe the portion of the amendment that would be different, that is actually quite different than what had maybe been contemplated in the 1997 OEA, is that, again, that 1997 OEA was designed for commercial purposes. And just as you pointed out, we need to be specific when we draft those kind of documents. But in 2004, it changed. It changed drastically. As Mr. Thompson noted, the building was going to go much, much higher. There was going to now be 3 floors of residences, condos, not just apartments, condos that would be owned by somebody else. So in that amendment, it specifically identifies the 2 ways in which 8th and New Hampshire is no longer the responsible or representative owner. And that is, one, if they no longer have any other ownership interest in the property, which they still do. And the second would be, Justice Biles, that if they resigned it to a condos homeowners association, which was never done. And so I think that if you take the idea of, does responsible mean representative equally between both documents? Yes, for our purposes today, with designating one owner, but if it's passed off to a homeowners association, a condo owners association, then that maybe means representative in that regard. But it really matters not only that the amendment was effective and that the designation as responsible or representative of 8th in New Hampshire, acting on behalf of all owners in a subdivided parcel, was effective. And that is where Mr. Russell's inquiry into how far he needs to dig in review of the OEA and the subsequent amendment errors. Mr. Russell identified that he looked at both the original OEA and the amendment and found section 6.11, which says it can only be amended by each and every owner, and felt comfortable with that. If you'll look at that amendment, it says owner with a capital O, and as we all know, particularly me, for Professor Keith Meyer, if you see something with a capital, you better go back to a definitional section. It's got to be there somewhere. And in fact, owner is defined in Article 1 of the original OEA. And that is, it means the owner of the entirety of either one of the parcels, the development parcel, or in our case, or the borders parcel next door. But then section 2.4 specifically contemplates the subdivision. And then the amendment that is executed in 2004 looks at 2.4 and says we are getting ready to subdivide these parcels. We need one to act on behalf of all of us. And not just in the performance of doing something, as Mr. Russell would try to convince the court that performance means something different than what performance actually is, and that's either an action or, in some cases, it could be inaction. If 8th and New Hampshire said to Trainer Investments, we don't like what you're proposing, they wouldn't have to sign the amendment. Is that performance? I would say that it is, electing not to. Performance is anything that the owner is either tasked with doing or has the right to do. And under this provision, they have the right, it's a valid amendment, the right to amend it as they see fit.
Counsel, I want to ask you a question now about 6.11 as you've just discussed it. Referring back to the 1.4, you're saying that 1.4, the only owners are ones who own the entirety of a parcel?
That is what it says. The OEA also contemplates in section 2.4 the subdivision that would create multiple owners with a capital O. But in that event, there is one that's designated. It is clear you need to designate this one owner to act on your behalf. And so much so that in case you don't, in case those owners don't do that, then it's default, there's a default provision as to the largest owner of the subparcel. Thank you for your time.
I've got one question. I just want to focus you on the OEA section 2.4 where it talks about subdivisions of the parcel, and it talks about multiple owners of the parcel. And it's a capital O. Are you saying that 2.4 provision only applies if the ownership of the entire parcel is held by more than one person and not subdivided of a parcel?
I'm sorry.
It says multiple owners of a parcel. And you're saying that owner talks about the entirety of a parcel.
Correct.
So it's almost like you're saying that multiple owners would have to be if 4 people owned fee simple of the entire parcel.
That is, if
In
that's what
2.4.
you've interpreted, that's not what I meant. The preface to section 2.4 is if any is divided into 2 or more parcels.
I'm
So
just trying to reconcile that language with your interpretation of the definition of owner in 1.4.
in 1.4 talks about the entirety of the
Right.
parcels, but 2.4 contemplates a subdivision. And in this case, there's somewhere in the
But talk
neighborhood.
about multiple owners and the owners is capitalized, and you told me that capitalization's got meaning. So it seems to me those two have to say something different.
I think that 2.4 supplements the definition of it to create the idea that the possibility, 1.4 talks about ownership of the entirety of the parcel. 2.4 necessarily contemplates what has actually happened and that the parcels are subdivided, creating multiple owners. But for purposes of the OEA, it's clear what they're intending is to designate one party to act on behalf of any multiple owners. Thank you.
May it please the court. The interesting thing about this is that my opponents in both prior courts have said the only way to reconcile the existence of this representative or responsible owner with the amendments provision is to say that the representative or responsible owner must be able to amend on everybody else's behalf, with or without their consent, even if the amendment that they want is detrimental to the other owners. By their reasoning, 8th and New Hampshire LLC and Mr. Traynor could get together and decide that we're going to rewrite the OEA to say that the condominium owners, except 8th and New Hampshire LLC, from here henceforth are going to be responsible for all of the grounds maintenance expenses for the entire block. They could do, there's no limit based on their
Well,
interpretation.
doesn't the clause in question say act on their behalf?
Act on our, and that's what I'm getting at. What does that mean? Does that mean that they get to amend on our behalf? I would say that there's a much more logical way to reconcile those two sections, which would be, of course, when you have 30 some odd doors in a building, like we do in our building, of course the adjacent owner needs to know whose door do I knock on if their trash is blowing over here and I need them to come perform their maintenance duties under the OEA and clean this up. It's 8th and New Hampshire LLC. But when it comes to amending, rewriting the obligations
But amending
of the
is a
parties,
power, I mean, even under your argument, amending is a power possessed by the condo owners
collectively.
collectively.
And only then
if
unanimously.
that power can be wielded by another can act on your behalf, why wouldn't that include the power to amend?
Why wouldn't it
Include the power to amend.
Because there's a very specific, I've pointed you to the only language in the OEA that speaks of amendment, which is a very explicit, very specific
It's a
clause.
provision. Would you agree that it's a provision?
It's a provision,
And
very specific.
2.4 talks about acting on behalf in the performance of the provisions.
Okay,
So it's a provision. We're talking about performing according to that provision.
okay. So,
Help me understand why
okay.
that.
So if you felt that the representative or the responsible owner had a role to play in the performance of 6.11, the amendments clause, it doesn't have to be that they get to sign on behalf of all the rest of us as though they've got some kind of power of attorney or something. To me, a much more logical reading of it would be that they get to accept the proposal from Mr. Traynor, I'd like an amendment, and then they get to circulate it around to us condo owners and say, would you all like to sign, and see if they can collect all the signatures that 6.11 requires, and then report back to Mr. Traynor.
Typically, that's not what act on behalf of means, is it?
Well, the 6.11 says you got to have all the signatures of all the owners to have a valid amendment. So to act on our behalf in an amendment process, that's all the representative owner could do, is go around and see if they could collect the signatures of
Does
everybody.
this go back to your point that we have to look at performance in that clause, and that performance means executing the contract, not changing the contract?
Absolutely. But I'd like to make actually two more points if I could. One is that, they keep saying that I was on notice. I should have known. It was clear that they could amend on my behalf when I bought the condo. And I say, no, it wasn't. The inadequacy of notice is very important here because it would have factored in hugely. I wouldn't have bought in that building. And I did argue this. The Court of Appeals didn't think I did, but I did argue this at the district court, that if you could find some language in the OEA that you could construct as to give 8th and New Hampshire LLC the authority to amend on my behalf, I don't think you could reasonably say that I should have foreseen that construction of it back when I bought my condo. And yes, I admit it, I didn't know at that time about Kokenge. I should have found it. I hadn't found it, the Kokenge precedent from the Court of Appeals. But if you look at my arguments that I made at the district court, if you read the transcript of my oral argument in support of my summary judgment motion, I basically argued exactly what the Kokenge court said. I just, without even knowing about Kokenge. And so then we get to summary judgment. If you don't think that I prevail on contract grounds and you feel like maybe I did, you just don't feel like I can get a reversal here, then I'm asking for a remand, and here's why. Because when we got to the summary judgment point in the district court, so the district court is considering my opponent's summary judgment motion, she talks in her decision about Kokenge and about, she found it, which was right of her to do. She researched it, she found that it applied, and that I would prevail because she found that I was not on notice that they could amend in a way that materially changed the development. But then she said I hadn't provided her any basis, any facts from which she could infer that the changes to the block were material. And I just don't understand that at all. I had shown her images of how the block looked when I bought and how it would look when they got done with their redevelopment. I had shown her evidence of the size change of the other building. I had shown her evidence of the use change and that those things were prohibited. And that clearly the draftsman of the OEA thought that those kind of changes would be material, or else he wouldn't have prohibited them. And yet she says I haven't shown her any evidence from which she could infer that the changes were material. Now, she might personally not have thought they were, but when she was deciding my opponent's summary judgment motion, she was bound to infer that they were, and at the very least deny them summary judgment so we could have a hearing where we could duke it out about whether or not the changes were material. If the case turns on the materiality of the changes, then when deciding their summary judgment motion against me, she needed to infer in my favor that the changes were in fact material.
Are there other
Any
questions?
other questions?
Thank you, counsel.
Thank you, and happy holidays.
Court will take this matter under advisement, and the court